Today we're going to talk about employment-based immigration. The employment-based immigration system to the United States allows approximately 140,000 people a year to achieve green cards. And when I say 140,000 people, that includes the worker, their spouse, and their children. They're all counted. From any particular country, only 7% of the total can be people born in a particular country. So please keep that in mind. There's 5 different categories. The first category, and we call them the EB categories, the employment-based category. EB1 is for priority workers. There's 3 subclasses there. 1 for people of extraordinary ability in their particular area. 2 for people who are outstanding professors and researchers. And 3 for people who are multinational executives or managers. The EB1 category usually has no backlogs no matter what country you're from, but the EB2 category, which is persons of exceptional ability or persons with advanced degrees, and by the way, when you say advanced degrees in the immigration law, that means either a master's degree or above, or possibly a bachelor's degree and 5 years of experience. If the job requires that, you're in the EB2 category, and generally your employer starts off the process with a PERM application, something that used to be called a labor certification. They advertise on the internet, they advertise in magazines and newspapers, and only if they find that there's no minimally qualified U.S. worker willing to take the job will you get a green card. There are a couple exceptions to that PERM application. The most prominent is national interest waivers. If it would be contrary to the national interest for your employer to have to go through the PERM process, you can apply, or they can apply. You can either self-petition or your employer can petition for you for a national interest waiver and just skip the Labor Department. But in order to do that, you have to show that doing a PERM application would be contrary to the national interest. Well, when would that be? Well, let's say you're working on a weapon for the Defense Department, or you're working on a cure for cancer. To substitute you in the middle of the project for some minimally qualified U.S. worker may be contrary to the national interest, and we've actually used that argument numerous times. The other group that's singled out to get national interest waivers more easily are physicians. Generally, if a physician works in an underserved area for more than 5 years, they can qualify for a national interest waiver. And then finally, the Labor Department has 2 lists, Schedule A and Schedule B. Schedule A is for jobs in short supply, and Schedule B are pretty much jobs that are never in short supply. There's only 2 occupations currently on Schedule A, and 1 applies to the EB2 category, and those are physical therapists. Now moving to the most common category, which is the EB3 category, again, PERM is a requirement. There are no national interest waivers if you're in the EB3 category, but there is a Schedule A profession, and that's for registered nurses. The next category is not as often used as EB2 and EB3, but it's sort of a catch-all. Special Immigrants, EB4. The biggest thing you should remember about this is religious workers, religious ministers are in the EB4 category, but there's a bunch of other small categories. If you work at a foreign consulate or embassy in the United States, you work for an international organization, certain juveniles are considered special immigrants. You really have to take a look at the list. And then finally, EB5 is the investor category, a category that's been in the law since 1990, but seldom used. Maybe 20% of the numbers have been used all these years, and now in the last couple of years, it's being used a lot. It's because people, they've never changed the amount of money you have to invest. It's always been $1 million. So $1 million in 2012 is not the same as $1 million when the law was passed in 1990. There's a lot more people who qualify. If they start a business with that kind of money and hire 10 U.S. workers, they can get a green card. If they locate the business in an area where the unemployment is 50% higher than the national average, or it's in a rural area, they can get by with a $500,000 investment, but still 10 workers. And then the really popular part of EB-5 is for people who are investing in regional centers. And the Immigration Service has designated over 200 of these centers. We link to all of those centers and their contact information from our website. And if you see a center that you like and you invest $500,000 in that center, the jobs will be created indirectly by the people who manage the center, and you never have to take any part in the management of the center. You don't even have to live in the same state as the center, and you can get your green card through EB-5. Now, the backlogs on some of these categories are really long. In the EB-1 and EB-4 and EB-5, there are no backlogs. But in EB-2 and EB-3, there are often backlogs, particularly per country backlogs, because of that 7% per country limitation. So EB-2, sometimes wherever you are born, you're subject to a backlog. But if you're born in India and China, there are so many people who've come over from those countries, and they go ahead and they get H-1Bs, which don't have any per country quotas. But when it comes time to transition to permanent residence in the U.S., all of a sudden they're in a backlog that on paper looks 5 or 10 years. In reality, it's 20 or 30 years. EB-3, on the other hand, there are backlogs from all countries, at least 6 years. And if you're from India and China, probably you're looking at least 30 years. So the question is, what can you do to speed up? How can you get a green card faster? Okay. Well, there's a few things that I want to mention. One is you can upgrade. Let's say you're in the EB-3 category. You got the job, you had a bachelor's degree, and you go to school and you get a master's degree and get another job. And you already have the PERM application. The immigration has already gotten and approved your EB-3 petition. You move to another employer, let's say with your H-1B visa, and the new employer requires the master's degree or the bachelor's plus 5 years. So you get a PERM application and the visa petition approved in the EB-2 category, but you keep the date, your place in line that you got under the EB-3 category. So that's a great way to speed up your application. Another way is, let's say you're from India or China and you marry somebody from another country that's not a backlog country. You can use your spouse's country of birth. We call that alternate chargeability, and you can get a green card and shave years off the waiting time. Another thing is called CSPA, the Child Status Protection Act. Too complicated to talk all about that in this video, but it keeps children together with their parents, even though by the time the parents are ready for a green card, they might be well over 21 years of age. And in 2 videos that we've already prepared, take a look and you can see how to shorten up your waiting times. And also, think about other ways to immigrate to the U.S. I mean, you may be a single person, you have a job, you're in the EB-2 or the EB-3 category from China, from India, or maybe just EB-3 and you're from any country in the world waiting for that 6 years, and maybe you're married to a permanent resident. They naturalize. Well, guess what? You're an immediate relative and you can immigrate right away. Maybe you're not married at all and you marry a citizen during the course of this wait for an EB-2 or EB-3. Keep applying every October, November for the visa lottery. If you're from a visa lottery country, you may be able to speed the wait. Just think about all the different options, and take a look at some of our other videos and you can see how to immigrate through these other options.